Greetings. Welcome back to another video. Now, this will be two parts. I don't like to make my videos too long because I understand people's attention span ain't that long. So this will be delivered in two parts because it's a nice amount of information. Now, someone reached out to me last year. They were going over their mortgage documents and they seen some things that didn't fit right with them. And they wasn't in trouble or anything at the time. They wasn't facing foreclosure. They was actually current. And they wanted to address the issues of the incomplete contracts with their trust. So they reached out to my company and wanted to hire us as the substitute trustee, which we greatly obliged. And we offered information based on the experiences of things that we are used to dealing with. So here recently, we noticed a corporate assignment that was recorded upon the property. So we decided to look and investigate. Then I happened to receive a notice of a petition, and that's what brought about this content. So please understand that I'm not an attorney, nor do I offer or do I give legal advice. The information that I share is always just from my personal experiences with things. All right. So just please understand that I cannot help you if you are in a bad situation already and you need to seek legal advice or competent counsel. All right. Now, with no longer ado, please understand, like I said, this will be two parts. Let's get to it. Today, we're going to talk about what is a corporate assignment of a mortgage. And I have a little article pulled up here I'm going to read over and we get right started. An assignment of a mortgage occurs when a loan for a piece of property, home or otherwise, is assigned to another party. In some cases, the other party might be an official lender that takes over the loan. A corporate assignment of a mortgage occurs when the third party that assumes the obligation for the loan is a corporation. Again, this corporation might be a lender that is officially incorporated, or it might be some other business or even an individual that is legally considered a corporation. All right. Now, the facts of this is during a corporate assignment of a mortgage, the legal obligation of one or the other party towards the mortgage is altered. The bank may choose to assign the mortgage to another lender, or the borrower may choose to assign the mortgage to a third-party corporation. In either case, the transfer initiates a change in the relationship that the parties have towards the mortgage. And since mortgages involve property and financial obligations towards it, the assignment results in a legal change in the status of the property ownership. Now, the significance is corporate assignment of a mortgage occurs most frequently during the foreclosure process. The original or current lender for the mortgage may choose to transfer the mortgage to a different lender. On the other hand, the borrower who is paying on the loan may also choose to transfer the obligation of that loan to a third party, who will then assume the responsibility of making payments. Both occurrences result in a corporate assignment of a mortgage, although the obligations about notification are different in both cases. Okay, now the requirements when one lender transfers the loan to another, the assignment of the mortgage becomes a simple piece of paperwork within the mortgage documents. In fact, the borrower might not find out about the assignment until a change in the loan occurs. When a borrower assigns the mortgage to a third-party corporation, however, the borrower must file official paperwork to record the assignment. The paperwork is simple and the forms are available online. All right, there's some links to go read some other articles. Now, the considerations: a corporate assignment of a mortgage is a fully legal transfer, but the requirements about documentation and filing vary by state. In the case of borrowers who plan to transfer the mortgage to a third-party corporation, it is important to research state laws by contacting the state real estate board and to consult real estate attorneys for guidance before signing any forms. An incorrectly documented transfer might create a continued obligation on the original borrower. Now, with expert insight, Mortgage assignments between lenders have become increasingly common, and they can create problems not only for the borrower who run into financial difficulty, but for the home buyers interested in a piece of property. As a result, real estate experts caution home buyers to research the title of the property to ensure that any assignment of a mortgage was completed fully and that there are not multiple claims on the property. All right. So that's a nice little reading right there. Give us a little synopsis on what a corporate assignment is supposed to be and, things to look for. Now, let's check out what Investopedia has to say. We have Investopedia pulled up here. Now, I've talked about this before in a previous video, so we're not going to dwell too much on it, but we're going to do a recap. Trust deed, what it is, how it works, and an example of the form. We're going to get straight down here. It says, what is a trust deed? A trust deed, also known as a deed of trust, is a document sometimes used in real estate transactions in the United States. It is a document that comes into play when one party has taken out a loan from another party to purchase a property. The deed of trust represents an agreement between the borrower and a lender to have the property held in trust by a neutral and independent third party until the loan is paid off. Although trust deeds are less common than they once were, some 20 states still mandate the use of one rather than a mortgage when financing is involved in the purchase of real estate. Now, trust deeds are common in Alaska, Arizona, California, Colorado, Idaho, Illinois, Mississippi, Missouri, Montana, North Carolina, Tennessee, the lovely state of Texas, Virginia, and last but not least, West Virginia. A few states such as Kentucky, Maryland, and South Dakota allow the use of both trust deeds and mortgages. All right, so now the key takeaway in this is in finance real estate transaction, trust deeds transfer the legal title to the property to a third party, such as a bank, escrow company, or title company, to hold until the borrower repays the debt to the lender. Trust deeds are used in place of mortgages in several states. Investing in trust deeds can provide a high-yielding income stream. All right, now let's get a little bit to understanding the trust deeds. Now, we have a trust deed is a transaction between three parties. Like I've always tell everybody, the three parties. You have lenders, officially known as what? Beneficiaries. These are the interests a trust is supposed to protect. Okay, let's click on beneficiaries. What is a beneficiary and what are the types? Okay, we got all these pop-ups. All right, what is a beneficiary? Is a person or entity who is designated to receive the benefits of property owned by someone else. Beneficiaries often receive these benefits as part of an inheritance. Okay, a beneficiary can be designated in the documents relating to a life insurance policy, a retirement account, a brokerage account, a bank account, and other financial products. It is important to designate beneficiaries for your financial assets so they can be distributed according to your wishes when you pass away. All right, now let's back out of there. A borrower, otherwise known as the trustor. This is the person who establishes the trust. Okay, let's click on trustor. What is a trustor? The term trustor refers to an entity that creates and opens up a trust. A trustor may be an individual, a married couple, or even an organization. Trustors generally make contributions of property to add to the trust. This can be done by donating money, gifts, and assets to other individuals. Trustors normally set up trust. Trustors set up the trust, okay, as part of their estate planning. Trustors do this by transferring their fiduciary duty to a third-party trustee who maintains the assets in the trust for the benefit of the beneficiaries. All right, so let's take the important key takeaways. A trustor is an entity that creates and opens a trust. Who? The trustor creates and opens the trust. All right, got it. Trustors can be individuals, married couples, or organizations. Trustors work with trustees. Who they work with? Trustees, okay, to safeguard and distribute their assets, including money and property. A trustee assumes the fiduciary duty from who? A trustor. So the trustor gives the trustee power, all right? Trustors are also referred to as what? Grantors or settlers. That's very important to take note of. All right, now let's back to what we're talking about, this deed of trust. We're really breaking this down to understand a little bit better. All right, now we have trustee, which we already know now at this point, right? A third party charged with holding the entrusted property until a loan or debt is paid in full. All right, so now in a real estate transaction, the purchase of a home, say a lender gives the borrower money in exchange for one or more promissory notes linked to a deed of trust. This deed transfers legal title to the real property to an impartial trustee. Who does it transfer property to? An impartial trustee. It does not transfer property over to the lender. Okay? It does not transfer property over even to the beneficiary. Transfer property over to the impartial trustee, typically a title company, escrow company, or a bank, which holds it as collateral for the promissory notes. The equitable title, the right to obtain full ownership, remains with who? The borrower, which is the trustor, as does full use of and responsibility of the property. This state of affairs continues throughout the repayment period of the loan. The trustee holds the legal title until the borrower pays the debt in full, at which point the title to the property transfers to the borrower. If the borrower defaults on the loan, the trustee takes full control of the property. Now we're not going to read this part, trustee deeds versus mortgages, because we want to focus just on the deed of trust right now. Okay. So with that in mind, notice what we're kept emphasizing here is trustee, and trustor. We never mention beneficiary. Okay, why? Because the beneficiary is not to do nothing from this contract but benefit from what's ever established from the trustor to the trustee. But that trustee is very important. That's a fiduciary. All right. Now let's take a look at another document. We have here pulled up now a corporate assignment of deed of trust. This document was filed March 4th, 2024. So this is a pretty recent document. It's a couple months old at this point because today is May 28th. So let's scroll down. You see I already have some information highlighted and little text boxes and things. Well, let's pay attention to a few things here. Now, it says when recorded, they want you to return it to MidFirst Bank in care of Nationwide Title Clearing LLC. At this address, we see this MIN number, which is short for MERS identification number. All right, corporate assignment. Now, as you see, the box says, who submitted this document to be recorded? Well, it was submitted by Nationwide Title Clearing LLC. All right, keep that in mind. In compliance with North Carolina statutes governing recordable documents and terms of the submitter agreement with the Cherokee County Register of Deeds. All right, for good, valuable consideration, the sufficiency of which is hereby acknowledged, the undersigned MERS Electronic Registration System Incorporated as beneficiary, as nominee for First Signature Lending LLC, its assessor and assigner. MERS address is here, and it says by these presents does convey, grant, assign, transfer, and set over the described deed of trust, together with all liens and any rights due or to become due thereon, to MidFirst Bank, a federally chartered savings association whose address is here, and this is Oklahoma City, Oklahoma. Its assessor and assigns us, which is the assignee. Okay, so MidFirst is the assignee, and the assigner is MERS, which is the beneficiary. Said deed of trust was executed. Information has been redacted from, it was executed by whoever this is to MERS, Electronic Registration System, as beneficiary, as nominee for its First Signature Lending LLC. Its assessors and assigns in the amount of $222,000, which was recorded here. All right, so we get more information here, right? And it says the date of this was March 4th of 2024. Mortgage Electronic Registration, which is MERS, is beneficiary nominee for First Signature Lending LLC. Its assessor and assigns. Now, who signs this document? Who is saying this? Lauren Astle, which is the vice president. So she's the vice president for MERS, huh? Now, the question is, what gave her the power and authority to do this? We just went over the positions and responsibilities of the trust, right? It didn't state the beneficiary had any power to do anything, did it? Okay. What does it say at the bottom of this? All persons whose signature appear above have qualified authority. Qualified authority, that's a very strong word, to sign and have reviewed this document and supporting documentation prior to signing. Now, this is coming out of the state of Florida, county of Pinellas. So this was signed in Florida, talking about a property in North Carolina. All right, the foregoing instrument was acknowledged before me by means of physical presence. So this notary is saying that the person came, physical presence, and what did they do? Physical presence, online notarization, or forth in the year by Lawrence. So she's saying Lawrence, physical presence, came to her to sign this document as the vice president of Mortgage Electronic Registration System. MERS' beneficiary is nominee for First Signature Lending, and its assessors and assigns, who, as such vice president, being authorized to do so, executed the foregoing instrument for the purposes therein contained. He/she, they is, are personally known to me. So, not only did she say she came in person, but Julie says that Lauren is personally known to her. Okay, you see that? So we might have to reach out to her and bring her up on some charges too, if this is what she's saying. Why? Because now let's check out something else. Let's do a little investigating, shall we? All right, let's go ahead and put her name in here and let's see what we find in Google. All right, we have a LinkedIn profile, pulls up right here at the top. Oh, what does that say? Nationwide title clearing. It doesn't say MERS. Let's click on that and see what's going on. Oh, so there we have it. Who is she? Astle, Lauren Astle. That's how you pronounce her name. I wonder, is that her voice? All right. She is a document review and signing specialist at Nationwide Title Clearing. Wow, really? Why does it say she's the vice president for MERS? And the notary backed her up. This is why we research things. She's been working with Nationwide Title Clearing full time for 13 years and 7 months. I wonder, signing specialist. She used to be a sandwich maker at Subway. Well, how about that? Start off as a sandwich maker. Now she's a fraud process. I'm sorry, an assignment specialist. Look at this. Greeter at the trolley. Greeter. golf course destinations. She's been pretty busy. Customer service representative. Some work history. Now she's in nationwide clearing, perpetrating as if she's a vice president for MERS. All right, now let's check out something else. Now let's recap. So far, we went into the discussion of an overview of what a corporate assignment was, what it pertains to. All right. Then we went back over the characteristics of a trust deed or deed of trust and the states that it's required in. And we also identified the three parties of a deed of trust and who has power to do what. Then we reviewed a corporate assignment. We identified who submitted the document and what the document consists of and who inside the document was doing what, which was Miss Lauren Astel on behalf of MERS, and she was signing as the vice president. Then we did a little bit more investigating on her name by doing a simple Google search, which identified her through LinkedIn as being a professional document review and signing specialist on behalf of Nationwide Title Clearing, which is something totally different from what she signed under the penalty of perjury on behalf of MERS. And she had a notary co-sign that signature for identifying who she was. Now, let's look at the actual deed of trust that pertains to this property. We have here identifying it by its MIN number, which is MERS identification number. Okay, we see that it was prepared by as to legal description only, Mark E. Randolph. He's an attorney at law. There's his address. Now, when this document is recorded, they're asking for it to be returned to First Signature Lending, LLC. Attention post-closing, there's an address. Then they tell you that this document was prepared by Lisa Allman Wallace. Then there's even a phone number. All right. You have the title order, escrow, loan unnumbered, and it starts with definitions to identify and tell you what's going on in this document. They have the date here. All writers, borrowers, name has been redacted. Borrower is the what? Trustor under the security instrument. We identified this in the definition of a deed of trust, right? Lender is First Signature Lending, LLC. Lender is a limited liability corporation. Big old gaps here. Now, I didn't redact this. This is the way the document is because these documents be templates. So they just be copying and pasting information in here. Under the laws of Indiana, they give you the address. Now we have the trustee. Okay, we've identified the trustor. Who is the trustee? Vantage Point Title. All right. MERS. We know who MERS is, right? Then it says submitted electronically by Mark E. Randolph, attorney at law. So an attorney uploaded this document to this county records in North Carolina. All right. We scroll on down, see more information here. I've already went over a note before. We're just going to the straight meat and potatoes. For this purpose, borrower irrevocably grants and conveys to trustee and trustee successor and assigns in trust with power of sale. Power of sale. So who has the power of sale? The trustee has the power of sale. Once again, the beneficiary does not have no power. Where does the beneficiary get its power? Now let's scroll on down here to the last page. We see this is 5 of 9. Let me move over here to save some time. Here we go, the signature page. Now what we have here is, just the signatures of the borrower. Where is the signature of the trustee? The trustee has to accept a fiduciary responsibility to be part of a trust. Where is the trustee's signature? Now we do see the borrower's signature, and then we have a notary acknowledgement here. Now check this out. This says the state of North Carolina, which is where this transaction is occurring, but someone scratched out North Carolina and put Tennessee, and I bet you that was the notary, because the notary is from Tennessee. So now we have a notary, a different notary, I assume. This notary's name, David Farrell, scratching out a state, and that's just crazy that he would even do that because, yeah, well, You get the point. All right, now let's look at something else.